foundation for what we're experiencing right now is the position taken by the president. And this is where I bring in Lawyer Boadu, because in the end, if a decision had been taken, first of all, this matter would not be in court in the first place. The foundation for where we are now is one, the Attorney General's own advice to the president. The president takes that particular position on the anti-LGBTQ plus bill.
I have something to say about it, if you permit me later on. I have something to say about the Attorney General's advice to the president.
Yeah, no, I want. Okay, I will come to that briefly. Does it now not concern you that in the midst of all this, and then the Attorney General now goes to court, reveals that indeed, as we have gotten to know now, it is not legally wrong what he did to file for an expedited hearing, even though the other party had not been notified? That's one of the concerns that the other party raised, that look, there was no notification of this expedited hearing, to the extent that the lawyers of Nelson Rocks and the were not in court when this case was heard. Taking into consideration all this, what should be the position of the presidency about a law or a bill that it appears, or is the case, that both sides of the House supported it?
Thank you. Thank you once again. You have asked a montage of questions from the presidency to the judiciary and all that. To begin with, I think, because we're talking to the public and educating the public, the letter asking for an earlier determination of a matter is a letter and not a process which is filed. So let's distinguish that. Once you file, you must serve the other party. But if it's a letter, it's an administrative matter. See, so when you use the word file, then of course it's preempting the service. So it's a letter you write to the registrar of the court. Of course, if you look at Article 125 of the Constitution, it says justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to the Constitution. And so if you look at just this, it means that in Ghana, it is constitutional supremacy. Now, if you look at clause 3, it says, 4, the Chief Justice shall, subject to this Constitution, be head of the judiciary and shall be responsible for the administration and supervision of the judiciary. And so that if you're writing to the registrar and by several cases in court, it is the Chief Justice that empanels a particular court in respect of cases, then the registrar would by all means have to send it to the Chief Justice for that. And so that's distinguishing filing and writing a letter. And I am very happy about the submission, in part, very happy about the submission of my learned friend and brother, Honorable Ayariga, in a sense that we have to be careful how we rope in the judiciary into our political discourse. As for members in parliament, they're already there for political purpose, political reasons, to agree and disagree, debate and whatnot. You see, the executive is going to take acts and laws and their own policy and going to execute it. So that's also, at least the executive and members of parliament stood on a podium for us to vote for them. So it's purely political. But the judiciary, let's easily go and draw them into our banter. And I'm so glad how you put it. And so it is not a rule of court that when you write, you should serve. But it's nice when you do. There are instances where I've reached court, travel maybe from here to Koforidua, travel from here, and the other lawyer would have sent a letter. I'm also guilty of that. There are instances where I'm overtaken by incidents that are probably two cases have clashed or something. And so I quickly write to the court. I wouldn't have had a chance to serve the other party. It may be that if you look at the letter, copy the CC, the other party, but he hasn't had a chance. So you drive all the way to court, whether in the same jurisdiction or outside the regional jurisdiction to court. And then when the case is called, the judge, counsel, the colleague has sent a letter and all that. It happens.
You even copy me.
Yeah. Yes, and that's it. So it's not a rule. It's nice if it is done. It's very nice it is done. So let's not. And then there's this perception of first come, first serve, and therefore before this was filed first, that should be determined first. There's no rule that says that, because there are several considerations the Chief Justice will have in impaneling, coming out a panel on a particular case. And there are instances where once it's empaneled, if one of the judges is not available at a particular time, the case has to be adjourned. Otherwise, you have to reconstitute the panel and all that. So let's really take the judiciary out of it. And I'm glad Thaddeus, my learned friend, my learned friend, has written to also express a desire for an earlier determination of the matter.
In fact, we have copies of that application. In fact, that the written notice to the Supreme Court. We'll put that on the screen shortly. But then you make a critical point, and which buttresses what the Honorable Mama Yarega indicated, that yes, it is not legally mandatory that the other party's lawyers be notified when there is even just an administrative letter that, listen, I'm a party to the case. I want an expedited hearing in this case. It is not legally mandatory, but it is only nice or right or maybe fair that you do so. Would you agree with the concerns raised by the lawyers of Dafiankpo, and indeed by extension some members of the NDC, that to the extent that this was not done raises questions about the conduct of the Attorney General?
Not at all. We've just said that it is not legally a requirement. And even before I answer this, I think there's another perception when you were introducing the matter. You seem to suggest that the case is determined.
No.
It is not.
It is the application.
It is only the injunction. So the substantive matter is still before the court. It is only the injunction. And there are instances where you come to court and you stand up to move the application. The judge will say, counsel, I'll rely on all processes that both parties have filed. And in this case, the lawyers for Honorable Dafiamakpo had filed the motion. All right, it was filed on the 20th. I have a copy here. Filed on the 21st of March, 2024 at 10 a.m. Granted that the search for the Attorney General was at 9 a.m. and this was at 10:15 a.m. So it was filed before the court. And so the court can look at, it's not every time that the court will allow you the luxury of coming to display your legal prowess and rely on so and so and annexure so and so. The court, in fact, the way things are going now, because there are so many constitutional matters before the court. Some even advocate that we do the US thing and also have a constitutional court. And then, because if you are not careful, the constitutional matters are depriving individuals, and there may be very serious germane cases where a land matter has traveled probably from the district court all the way to the Supreme Court. That takes years. In a report, in 2014 report of the judiciary, they aim to dispose case of as quickly as possible. They gave themselves, and I thought it was probably adventurous. They gave themselves 6 months to dispose of cases. All right. And then this delays the whole process. So if because of a constitutional matter, the court cannot sit on other private members' matters, and there are several other very important cases, then you see, we need to ensure that all parties are heard. Now, so I will not fault the Attorney General one bit in this matter. Indeed, if I take my matter to court, the Supreme Court, I want it to be heard expeditiously. And so if you call for it to be heard expeditiously, there's nothing wrong with that. The statement of case part is about to be heard. Okay? And so, and even the Supreme Court is not in a high court where you have a long time to ask questions. And Supreme Court, most of the time, you get up and say, my lord, I have filed my statement of case on such and such a date, and I rely on that filed. I have nothing. That's why we toy with this phrase. I have nothing useful to add. Because unless the panel begin to ask you some fine details of the law in respect of the fact, then you have the chance to. So,
but must all these processes be legally minded?
There's this instance where when you're going to the Supreme Court, you don't sleep. You spend nights and nights and look at it, because a question can come from anywhere. Most of the time, when you've done all that, you go, they'll just say that, and the judge will say, okay, come on this date for judgment. You see, so there's nothing wrong with the judiciary. As for the judiciary, I'm very careful. It's not for nothing that for all the coup d'etats are happening.
All lawyers are careful when it comes to the judiciary.
Yeah, because you see, not just that. You see, we drink from the streams of justice, all of us.
Yes.
It's not for nothing that for any of the coup d'etats, executive. There's something we are drinking from the Supreme Court. Let me answer this. It's not for nothing that we.
It's for something.
It's not for nothing that from all the coup d'etats, right?
Yes.
Executive is done away with.
Yes.
Legislature is done away with, but they keep the
judiciary.
The only time, the closest they've come to is that, okay, we don't have a Supreme Court. Why? Because the Constitution itself is thrown away. So what's the Supreme Court doing? And it ends at the appeal court. All right. But Papa J himself, two-time coup maker, he kept the Supreme Court. Why? Because he knows the importance of it. So when we are going close to it and we're drawing them into the politics, with time, we begin to color them. This is this color, this is this color, and then it doesn't augur well.
I see, but
let me add something.
Yes. I want us to just find out this. If all the processes have to be legally binding, or at least we have conventions also play a role, I mean, in our governance processes, does it not?
Well, conventions do play a role, but at the end of the day, you need to distinguish between what is legally mandatory, according to the rules, and what is conventional, for which if you did not comply with, there will really not be any penalty. Just that it doesn't showcase you as a gentleman or a lady. And so, like he said, it would have been appropriate for the Attorney General to notify the other parties that he's written to the Chief Justice to ask for an expedited hearing of the matter, so that they are aware. But he hasn't done that, which may not necessarily be gentlemanly. But then his argument is also legally sound, that, but why would you, the one who brought the matter, not be interested in an expedited hearing of your matter? What are you running away from? So, you know, it's quite a tricky situation.
That fits the narrative that there's a tit for tat.
Yes.
As for me, from day one, I have been honest and straightforward in this matter. That we are engaged in a fight with the president. Is that okay? And that we will do everything humanly possible, using whatever legal tools we have, to do to the president what he's doing to the rest of the country, which is undermining the Constitution. I haven't hidden that. Going to court, you know, what we did in Parliament, is all part of the engagement with the president to compel him to do the right thing.